Hi, Josh Denbo here, consumer protection attorney, back in the saddle shooting more content. I want to continue the series on how banks defraud homeowners, consumers. This is about successor and interest problem. It's when somebody dies and leaves a property subject to a mortgage and a loan to an heir. Under the law in every state, because it's federal, the lender or the mortgage servicer has to recognize the fact that the new heir, the new owner of the property, has the legal right to assume the mortgage. Now, banks, meaning the investor and the mortgage servicer, they absolutely hate this. Hate it, hate it, hate it, hate it. And in a way, you kind of understand why they hate it, because they give loans based on the creditworthiness of their evaluation at the time of the original borrower, right? But they don't know anything about this heir. This heir might not have any money, might not have a job, might not have any income, might not be able to handle the payments. In which case, the bank just doesn't want to be left holding the bag, so they're legally obligated to accept this new successor in interest this successor has to be allowed to assume the mortgage under the law, but they hate it so much that they cheat. And if anybody has run into the situation, I know you have, because just yesterday I had a long conversation on the phone and another conversation on the YouTube comments on a different channel, on a different video, in which people were facing this problem. So one of the things that the servicers do is they say, okay, yeah, you can assume the mortgage, just complete this modification application. And then they make the modification application subject to your creditworthiness, or the creditworthiness of the new owner of the loan, or owner of the property, which is not the way it works. That's not the way it works. They're not allowed to do it. It's a violation of RESPA, and which means it's a violation of federal law. In some states, including New Jersey, it's also a violation of state law. All right. So what do you do when a mortgage servicer simply refuses to follow the law? It's not as easy as it might seem. And it's because the steps required to set up a case for a RESPA violation on the successor in interest are significant. But what you need to do at the very least is demonstrate, one, that the person passed, two, that you are the heir, three, that you are interested in assuming the mortgage. And as long as you do that, they're obliged to allow you to assume the mortgage, no questions asked. Are they going to do it? I don't know. That's hard to say. I recently resolved the case, and I don't win all my cases because nobody does. You get on the internet, you see a lawyer saying, I win every case, they're full of baloney. But this is a case I just won. So a woman came to me, her husband died. He was the only one on the loan. She wasn't on the loan. She wasn't even on the deed. This is his second marriage, and he owned the property long before they got married, and he has a child from a prior relationship who had a claim against the property. She was the only one living in the house after he passed. She tried to make payments. The bank returned the payments because her husband hadn't paid in 6 months before he died because he was sick and was in foreclosure. She didn't know. She called the servicer. The servicer wouldn't talk to her because she's not on the loan. She continued to try to pay. They continue to send the payments back. Then she gets a notice they're going to sell the house. And then she reached out to me. So I tried to get the bank's attorney to see sense, and they refused because they're jerks. I filed an emergent application with the court. The court said, yeah, we're going to stay this sale so she can get her successor and interest documents in, get her modification in. So we got the successor and interest documents in, we got the modification application in, and then the bank refused to review it and insisted on going to sale again. We went back to court. The judge then adjourned the sale for 4 months and ordered the bank to review the modification application, which wasn't really necessary in the normal assumption of mortgage. But because she was so far behind, because her husband hadn't paid for a while, because he was sick before he died, and because the bank wouldn't accept her payment, she needed a modification to get current. So it's perfectly appropriate in that circumstance for a bank to demand a modification. She submits the modification application. The bank, per their guidelines, had to accept it because she met all the conditions. Brought her current, saved the house. Happy story. But that's a good story. There are bad ones. I get them all the time. People reach out to me too late all the time. My house was just sold. My husband died. I tried to take it over. The bank sold it. I didn't know. What can I do? I can't do anything. Once the house is sold, there's nothing I can do. It's just not a case I can take. I wish I could, but I can't. So if you're running into a situation here, listen to the video, understand what you need to do, and follow up and ask questions. I'm available to answer them. I don't care what state you're in. I only practice in New Jersey, but I can find you attorneys elsewhere in almost every state. But more importantly, I can just answer your questions, so you're not walking into this thing blind, confused, don't even know which way is up. All right? I hope this is helpful. Stay strong. I hate banks, but I do like you.